transfer it or set up a new PAC, you can give it to a 501c3. Or you can return the money to the people who gave it to you, if that's applicable. Now, the other sections of the bill set up a penalty of $1,000 for violation. Section 7 at line 285 allows the Secretary of State's office to issue advisory opinions. If there's any question about whether an expenditure is permitted or not permitted, it puts that authority in the Secretary of State's office to at least give guidance and provide a safe harbor for candidates if they follow that guidance. One very important provision I want to direct the body's attention to, line 279, and this was in agreement with the Senate. Any contributions that you already have or that are in a campaign account before January 1st, 2017, these rules don't apply. The old rules apply. What the Secretary of State's office is going to do is develop a form where you can keep up with prior existing balances before 2017 and balances for monies raised after. In other words, it's a grandfather clause. It phases this in so that people who were candidates or office holders under the current set of laws can keep the funds they've got and maintain them as they're currently maintained. In other words, it's an effort to phase this in so that after 2017, monies raised will be subject to those prohibitions. Otherwise, any of the campaign finance matters that are contained in the conference report are really cleanups over current law. But again, these are significant campaign finance reforms. They increase transparency. They clarify that these funds are not to be personally used as defined by the statute. And it sets up something that I think will make us all more accountable to the voters who sent us here. Mr. Speaker, that's my explanation of that section of the conference report.
You yield for a question?
Yes.
Gentleman from Lafayette, Mr. Hughes.
Thank you. Will the gentleman yield?
Yes, sir.
My question is, as it relates to the termination report, and specifically I'm looking at line 333 and 332 where it defines political action committees or PACs. So under this, as the committee report came up with, a politician can still retire or not seek office, transfer all the funds in their campaign account to a PAC they create and still be able to pay themselves out of it. Is that correct?
Well, gentlemen, the line you're talking about is current law in terms of the definition of a PAC. And I guess if you're referring back to Section 4 of Section 1 of the conference report, that doesn't change the definition of a PAC or political committee or a candidate as it's already under 2315-801. So I'm not up here to give legal opinions. I'm just saying that the prohibitions in Section 4 of Section 1 of this report are new, and they are stronger than what they are now. Otherwise, it doesn't change what a PAC is or isn't.
So then my question is that a former candidate can transfer their money into a PAC they create and pay themselves if they meet the definition at 331.
Well, they can certainly create a PAC, and they can transfer those funds, and they can use those PAC funds for whatever else any other PAC could do.
Thank you, gentlemen.
Gentleman from Lee.
Thank you, Mr. Speaker. With the chairman yield. So if up in Robert E. Lee County, where I got a few shackles of change stored away in my campaign account, would it be wise for me to get together good brothers and good sisters and celebrate the time that you've been together at Park Heights Restaurant and get rid of that money by December 31st? Is that what you're saying?
I can't offer the gentleman from Lee wisdom, but, you know, again, if it's campaign related or if it's related to holding office, then those funds are permissible use.
Well, gentlemen, when you get together with good fellas and good ladies, don't politics always come up?
Well, not always, if we're lucky.
Well, you running a different kind of politics than I am then.
Even after January 1, that money is his.
Well, and
Gentleman from Scott, Mr. Miles.
Well, to respond a little bit further to the gentleman from Lee's question, the provision that we agreed with the Senate in terms of the effective date of January 1, 2017, the campaign funds that office holders have now or prior to that date, 2017, are still going to be treated under the old rules after 2017. In other words, there'll be 2 line items, and it'll be up to the candidate and the Secretary of State to disclose that and to total it, so you can have your dinner with good times and good friends in your old campaign account funds even after January 1st. Doesn't have to be a New Year's Eve party.
I got you.
Move final passage.
Do you yield for further question?
Yes, Mr. Speaker.
Gentleman from Scott.
With the gentleman kneel.
Yes, sir.
We asked this question, I think, several weeks ago, and I think I even offered an amendment, and I think the senator from Free State of Jones offered an amendment on the Senate side as well, talking about why are we waiting on this if we want to. I'm talking about we've been talking about transparency and sunshine and everything. Why? I'm talking about why do we have to wait until then?
Well, first of all, we're in the middle of a reporting cycle. That cycle ends December 31, 2016. So the idea would be that this starts a new cycle. The same transparency, actually more transparency, would apply after this bill is effective than what currently applies. So we're making an effort to phase this in. Again, under the current set of rules, everybody who's in this room sought office. Those rules will still continue to apply, and basically the consensus of the conferees was to allow a phase-in period so that those rules are not interrupted midstream.
So in that phase-in period, we can still pay for our apartments, buy our special underwear that we only wear when we're in session, have a second form of income, and I'm not saying anything about that, John. But what I'm getting at is that sounds good in here, but out in the real world where most of us are from, transparency is transparency, and it seems like that if we were going to put true transparency, wouldn't it went on a passage?
Well, gentlemen, I haven't been here as long as you have, but I will tell you that this gives us transparency. This moves us forward, and this sets a rational timetable for implementation of what is the most significant campaign finance reform since I've been involved in state government back in 2008 at the Secretary of State's office. So I think this is a big move forward. It certainly makes sense to institute these reforms in a way that makes their time for everyone to know what they are and gives time for the Secretary of State's office to implement the related administrative procedures. So I think it's a big move forward.
Well,
and look, you've still got to report everything that you do today, just like you would up until January 1, 2017.
Yeah, well, I agree with you that it's a big move, but I kind of think like the senator from the Free State of Jones on the other end of the building had with his amendment, and I had with mine as well, that if we wanted true transparency and instead of picking and choosing when we let the sunshine in, that we would have let it done on passage. But thank you for getting us to this point as well.
Thank you, gentlemen. Move final passage.
Gentleman from Forest, Mr. Watson.
Thank you, Mr. Speaker. If the gentleman will yield.
Yes, sir.
Okay. Under the conference report, is there a prohibition against an office holder making a payment, just say for someone else's utility bill who's unable to pay?
Well, the prohibitions that are specifically included in the conference report start at line 157. I think that if that person who's unable to pay the utility bill is the office holder or the office holder's family, then yes. But as far as expenditures to constituents, if those expenditures are related to holding the office, then I think it would be permissible under this.
Well, my question is a constituent's utility bills, someone who is unable to pay his or her bill.
Well, that's exactly why we have the provision in here for the Secretary of State's office to offer advisory opinions. Okay. I can't get into every hypothetical that everyone would come up with, but again, the touchstone is that if it's related to campaign expense or office holder expense, it is permissible under this campaign finance reform bill.
And you may have mentioned this, gentlemen, is there a prohibition against just charitable contributions from your campaign fund?
There are not, gentlemen. In fact, one of the permissible uses of campaign funds raised after January 1, 2017, in the event of a termination, for example, if you leave office, is to make those contributions to any 501c3.
Yeah, my question is, after the effective date of this act, is there a prohibition against just charitable contribution from your campaign fund?
Well, I'll direct the gentleman to line 219 under Section 3 of Section 1 of the conference report. Gifts of nominal value and donations of a nominal amount made on special occasions, holiday, retirement, graduation, those kind of things are specifically listed as permitted expenditures.
Okay. In the event that an individual is paid, just say by the state of Mississippi or another political subdivision, to take a trip, in other words, a trip associated with that individual's office, under this conference report, would that individual still be permitted to go in his campaign fund and pay for the same trip?
At line 187 of the conference report, travel expenses are addressed. Travel expenses are prohibited, but if the travel is related to holding office or being a candidate for office, it delineates that travel is permitted, and that can include issues that we would consider in this body, other travel related to holding office.
Okay. If I were just say an insurance or salesperson and I had an annual conference that I had to attend, would I be able to go to my campaign account and pay for that annual conference?
If it relates to office holding or running for office, then yes. If not, no.
So I could make an argument that it did relate to holding office, because any of these conferences, whether it's the American Bar Association, National Bar Association, the Magnolia Bar Association, could be argued to be within my scope of office. Would I be correct?
Well, gentlemen, I'll answer your question this way. We just all filed taxes yesterday, and every year my accountant and I, long ago actually, we had this discussion, and he always says in filing taxes you can be as conservative or as risky as you want to be in terms of how much of a deduction you want to take or how much you want to write off here and there. I think this same principle applies. If the office holder is comfortable that whatever travel relates to holding office and the duties of the office, then go for it. It'll still be disclosed. It's got to be transparent. The other thing is that the conference report addresses, again, in this same, starting at line 187, travel that is a mix. If you go to the bar convention, for example, and you speak, but you end up staying 7 days down in Florida, that's not going to be campaign related except for the one day you were there. Again, that's going to be up to the candidate or office holder to disclose and determine, and again, can go to the Secretary of State's office for guidance if need be.
Okay, what if you're down there, you decide to go to the state capitol and tour the state capitol and talk to some elected officials down there? Would that be within the provisions of this conference report?
Well, I'm not aware, gentlemen, that the state capitol has an office in Destin, but if it were...
I'm not saying Destin. I'm saying in Florida.
Well, again...
I think that would be Tallahassee, sir.
The conference, well, if you're in Destin and you drive to Tallahassee and you document all of that, again, Section I of beginning at line 187 addresses how you should treat that travel.
All right, thank you, sir.
Move final passage, Mr.
Your further question.
Sir.
Jim from Washington, Mr. Hine.
Thank you. Gentlemen, you here?
Yes, sir.
I have a question. My question is, in most of our district, our community, tragedy hits from time to time. And it's possible that someone might not have insurance or something for burial, to be buried, and they do a fundraiser. Can we donate money to assist their family, especially say an infant or so dies? Can we donate to those causes like that?
Well, under Section 2 of Section 1 of the conference report at line 169, it says funeral, cremation, or burial expenses are prohibited for deaths within a candidate's or office holder's family. So as long as you're not related to the person who passed away, again, I would direct the gentleman's attention to lines 214 through 222. Charitable donations, gifts, special occasions, those expenses are permitted. And it's obviously going to be in the candidate's discretion to make those donations and then disclose them.
Okay, well, I'm glad you talked about family. Is it immediate family or distant family? So let's just say I have a wayward cousin, second or third cousin, who doesn't have any burial insurance and dies, and he's a family member. Can I assist in his burial?
Well, the conference report says family members, but I think that's a perfect opportunity to seek an advisory opinion from the Secretary of State's office.
So why y'all didn't just say immediate family?
Well, because we didn't. I mean, gentlemen, I can't address every hypothetical that we can bring up today, but again, there's a lot of flexibility in this act, and the key touchstone is your campaign expense related to holding office or running for office, and I think if you can answer that in the affirmative, then it's going to be okay. Okay, gentlemen. So if you were seriously talking about trying to ensure that we were transparent and all, so why you didn't tell every dime starting from and after passage that members in this body has roll over into the new year, and you can't spend a dime unless it's in there? Why are you giving people opportunity to clean out their accounts and do what they want to do with their accounts up until January 1st? Some of y'all have $200,000, $300,000 in y'all account. Y'all gonna hide that somewhere so you can go off to the clear blue yonder? Why you didn't push it all over there? Well, gentlemen, I feel like I answered that question in response to the gentleman.
Well, I didn't
Scott.
hear you, so I'm asking you now.
Well,
don't be a smart tail now.
I'm not
answer
trying to
the question.
Well, no, I answered the question at length. Actually, we're phasing this in because we're in the middle of a campaign finance reporting cycle now. We also feel like it is a reasonable compromise with our conferees from the Senate to allow a phase-in period for people who have already been in office and have already raised money under the currently existing rules, to allow those accounts and amounts to be segregated out to give some time to phase into this program. Frankly, gentlemen, I think campaign finance reform is important. I'm passionate about it, and if that's what it takes to get this through, to give a year's lead time or 8 months lead time to get started, I think that is a perfectly a reasonable compromise.
Gentleman Lounge, Mr. Smith.
Okay.
You have a question?
Very briefly, I appreciate your work. I'm not going to vote for your bill. I would just like for you, if you would, and I know you're a good lawyer, and I know you can give an explanation in 50 minutes or 50 seconds. We continue as a body, is it not, to surrender our sovereignty to a executive department or executive office. For instance, we continue to let the Ethics Commission oversee us and fuss and cuss and discuss us. In most other states, Ethics Commission is the commission or the committee in the House of Representatives. Do you know that?
Well, we actually looked at that, gentlemen, and frankly, we decided against allowing the committee of this body or of the House of Lords from having such authority because it lets the fox guard the hen house. In other words, if a member is on the ethics committee, I'm actually on that committee, and my opponent asks that committee for an opinion, or I ask for an opinion about a campaign finance expenditure, it's very difficult for that to be seen as a fair and equitable answer because the committee members have an interest in the outcome of that election. That's why we didn't respond to that point.
All right, junior gentleman from Madison, let me ask you this. Are you satisfied for us to let the Secretary of State to have some supervisory authority, obviously the advisory opinions, and when some of us do something wrong, and you know darn well we're going to do something wrong because we're from Mississippi, are you satisfied that let the Secretary of State's office be the one to guard the hen house?
Well, I wouldn't call what they do under issuing an advisory opinion supervisory. It is advisory. So really, I don't know that the Secretary of State's role under the new set of rules that are proposed in the conference report, really amplify his authority that currently exists over
Gentlemen,
campaign
you are
finance.
a lawyer, and you know that if we do something wrong, somebody's got to either report us, bring charges, write us letters, scream at us, go to the press, something. The Secretary of State's going to do more than do advisory opinions, isn't he?
Well, currently he's required to put out the list of late filers, for example. I mean, that's current law. The Secretary of State's office publishes reports that we file as candidates and office holders and publishes them on the website. I mean, I don't think any of that changes.
All right, gentlemen, let's see if we can talk like laymen, which is awful hard. It's like speaking in unknown tongues, I know. But can you tell us if Jeff Smith does something wrong, or the gentleman from Forrest, one of the more senior members, does something wrong with his expense, with his election account, who's going to turn him in? Who's going to do the misdemeanor prosecution?
I think that remains with the Attorney General's office.
All right. So what you're telling us in that we're going to have two executive agencies then that would sort of overlook and micromanage us a little.
We already do, gentlemen.
Gentlemen, you haven't been in politics long. You've been blessed. But for years, we filed a campaign finance report with the Secretary of State. And as long as you file it and fill it out, you've done all you have to do. Somebody's got to oversee our sins now. Is that correct?
But that's currently the Attorney General's office. I may not be as new to the politics as the gentleman from Lowndes is, but part of my time was 3 years at the Secretary of State's office.
And, sir, did you not know in your tenure as Secretary of State's office that the penalty was for not filing? Is that not correct?
It's for late filing or not filing. That's correct.
Right.
But there are other laws that relate to filings on campaign finance, but those are the province of the Attorney General.
And listen, you've got the votes. I'm wasting everybody's time. But have you thought, gentlemen, when you get through talking with the senior gentleman behind, have you thought possibly of letting the ethics committee of this House, do the policing, the filing, the sanctions, and the overview?
We did consider that, actually, gentlemen. And as I'd mentioned, the problem with that is you have incumbents who may be running for office against opponents who then have to go to that committee to get an advisory opinion. We just didn't feel like there was a way to effectively put that in this conference report as cleanly as what's in the Secretary of State's office. And I'll also point the gentleman to Section 5, line 271. There is language in here about willful violations. In other words, we actually put in the word willfully. So an accidental violation, some sort of good faith effort, is not going to be punished under the law. And there's an assessment of $1,000 that actually goes to the Public Employees Retirement Fund. It's not to the Secretary of State's office.
Well, I appreciate that, but I think we all know as lawyers that if something's not done willfully, as a general rule, it's not a crime. Is that not correct, sir?
I'm sorry, gentlemen.
Don't all crimes generally have to be willful?
I don't know that all of them do. I'm certainly not a criminal lawyer, but we certainly put that word in here deliberately in order to raise the threshold for flagrant violations.
Sir, I appreciate your work, and as I'm pressing my no button, I'm going to be thinking about you.
Thank you, gentlemen.
Jim Mark Tibberhall, Mr. Ellis.
Thank you, Mr. Speaker. Mr. Chairman, you yield.
Yes, sir.
Not to belabor the point, but I'm a little curious. This bill 797, is this the bill that actually originally contained the early voting?
I think, gentlemen, very early it contained that. In the House version that we actually voted on, it did not contain early voting. It was
stripped out of the 400-page bill.
Well, I think it started at 600 pages and then it became 300 pages because we removed some things. What is in 797 is the rewrite and updating of the whole election code.
Okay, so the early voting was stripped out by the House of Lords. Is that what you're telling me?
No, gentlemen. We actually voted on 3 separate bills over here. I can't remember the number of that bill, but we voted on online registration, a separate bill for the early voting provisions,
right,
and then this bill, which is the technical rewrite.
But we did pass the early voting from this House.
I believe we passed all three, gentlemen.
Right. And so when it got to the House of Lords, they cut it.
I can't speak to the wisdom of the House of Lords, but yes, you're right.
They killed it. Okay, now, you probably already mentioned this, and just for clarification, the penalty section in there for violations, where is that found? What section is that found in?
It's Section 5 of Section 1, I believe. It's lines 271 and following.
And who renders the decision about the enforcement of the violation part of the penalty?
I believe that to be with the Attorney General's office, as is the prosecution for, I guess the district attorney could do it also.
So the Secretary of State would have to refer back to the district attorney, and then the district attorney would have to actually do the prosecution.
That's right. The Secretary of State's office does not have prosecutorial authority now, and they won't have it afterward.
Okay, thank you very much, Mr.
Gentleman from Newton, Mr. Rushing.
Thank you, Mr. Speaker. Gentleman yield.
Yes, sir.
Obviously, y'all put a lot of work into this, gentlemen. You and I have had some discussions on this. My question is, and I must have not heard you on, where on the report do we file, assuming hypothetically it takes place, and I can't prove that it does because I'm a lowly representative and I've never gone on a trip, but let's say hypothetically a PAC or some lobbyist or some agency or some corporation wants to take me on a fishing trip or a hunting trip or just wants to send my family to Florida, as the gentleman was talking about, on a vacation. Where would I report that on this form?
Is it coming out of your campaign account,
No,
gentlemen?
I'm not paying for it. I'm saying if somebody just wants to gratuity give me this because I'm a legislator of this great state.
This doesn't address that, gentlemen. This addresses if you had taken your campaign funds and gone on a trip and paid for them in that fashion. In other words, it doesn't change anything with regard to trips, travel, other things like that that are not paid for out of a candidate's campaign funds.
So you're telling me, gentlemen, if I receive a family vacation on the gratuity of a corporation or a lobbyist, that I don't have to report it?
Do you have to report it now, gentlemen?
Pardon?
Do you have to report it now? It's my understanding it would not be reportable as a campaign finance expenditure or a donation. You could certainly report it as an in-kind contribution.
I can.
Well,
but do I have to?
It's my understanding, again, gentlemen, that unless it's a campaign contribution or a campaign expenditure, this is not addressed by this bill.
So we're gonna magnify, micromanage, and overlook our campaign contributions of $200, but I may get a several $1,000 gratuity trip to wherever to do whatever, and I don't have to report that. That's what you're telling me?
I think that's the current law, gentlemen.
But y'all are attempting to solve some obvious problems that we have with lobbyists and holding political office and who's donating to who. Why wouldn't we want to shed some light on this particular situation?
Well, gentlemen, you answered your question. We're attempting to solve some of the problems. Obviously, this doesn't solve all of them. And I mean, I see this as a great first step and a step forward on campaign finance, but that's all it is.
Yes. So you think possibly we may look at future date of looking into that area, because if we're going to do it right, gentlemen, let's do it right, and let's shed the sunshine on everything.
I agree with the gentleman.
All right, gentlemen, and you said there was a $1,000 fine mentioned, I think I heard a while ago?
Yes, for willful violations of the section.
Is there any type of appeal process in that, or is just somebody slap my hand and say I owe $1,000 if I do wrong?
Well, no, I think that would go through the usual court process. In other words, right now the way campaign finance or election violations are handled is through the legal process, criminal law. And I mean, that's why it says willful violations. As far as administrative penalties and those kind of things, again, if you don't file your campaign disclosures or if you file them late, you can be fined, but that's current law also. And that's through the Secretary of State's office.
Yes, sir. Okay. Thank you, gentlemen.
Thank you.
Jim from Rankin, Mr. Moore.
Okay. Thank you, Mr. Speaker. Gentlemen, I'm sitting here and I'm listening to a lot of discussion. I have grave concerns here. Now, there's 122 members of this House, and there's not a one. We wouldn't be in this office today if we didn't run all over our districts, day in, day out, late at night, early in the morning, doing things for our constituents, doing those things that are necessary to serve our people. Now,
technically, I don't think I'm campaigning when I'm doing that. I'm just doing my job. Now, and as a bunch of chairmen out here, and we go all over the state to do things. As chairman of education, I know I do from one end to the other. Well, I always pick up those expenses out of my campaign account. Am I going to have to pay a fine for doing that if I'm doing it and have to report every stinking mile that I drive and every meal that I buy and every hotel room that I pay for, because, or that the people that donate to? Am I going to have to do that? I mean, I report the expenses as according to the law now, but I feel like I'm going to have a gun to the back of my head, and I'm going to be very careful. And there's a bunch of big holes in here, just as the gentleman from on the other side of the chamber pointed out. Well, the gentleman from Lowndes, the gentleman from Newton, I just see that we're being penny wise and pound foolish here. And you just said it just a second ago. If we get $1,000 fine, somebody's going to have to hire an attorney, which would make a lot of attorneys in here happy. And Ed Blackman, I can see or the gentleman from Madison, he's already getting excited about it. But it gives me great concern, gentlemen.
Gentlemen,
question.
Yeah.
Gentlemen?
What about foundations and how are those going to be treated here? And what about if you have a fund called an education foundation or something like that? Can you?
Well, gentlemen, the way I would address your question or questions is to say simply this: everything you described about traveling around the state while in office, specifically permitted under this bill, specifically fine. You report it the same way you'd report it now. If it's over $200, you itemize and you show that as a campaign expenditure. And so none of that changes. We're very sensitive to that because there's a lot more than just buying yard signs and bumper stickers 6 months out from an election involved in running for office and holding office. All that you described is allowed. Foundations are specifically addressed, and if you want to give to a 501c3 or make another charitable donation like that, specifically permitted. And travel around the state, all those kind of things, to the extent it's not covered by per diem that we would get for holding office, is also perfectly permissible. So I don't think anything that any of the gentleman's concerns are left unaddressed in a positive way by the conference report.
Okay, one final question. How much of this was driven by articles in the local paper over the last few months?
I can tell you from my point of view, gentlemen, not a bit.
Gentleman from home, Mr. Clark.
Thank you, Mr. Speaker. With the gentleman yield.
Yes, sir.
Gentlemen, I got a couple of questions. One is the termination report. And I think the gentleman said that one of the organizations would be a 501c3. As the gentleman know, there are some churches and other, I would say, not-for-profit organizations that are not designated as a 501c3. So if I terminate and want to give it to my little church in Ebenezer, Pleasant Green, which is not a 501c3, can I donate those funds to my church?
Well, what the language says in line 264, gentlemen, is that it can be donated to a tax-exempt charitable organization as that term is used in Section 501c3. I'm not a tax lawyer either, but my understanding is, again, if there's any ambiguity, the Secretary of State's office can offer an advisory opinion, but I think a donation to a church is not going to be questioned.
Okay. And a couple more questions. Gentlemen, I'm going back on the funeral situation because I do that quite a bit. Now, when I read the language, the line 169, it says funeral, cremation or burial expenses, including any expenses related to death within the candidate's family, candidate or office holder's family. Now, when I read that, I look at each one of those three different terms as separate and apart. So are we excluding, you sure we're not excluding giving donations for funeral expenses of constituents?
Well, this is specifically related by its language to the candidate or office holder's family.
Yeah, and I understand that, but the way I read it is when you put that comma in there, you're separating funeral from candidate or the office holder's family. expenses.
Well, I think the gentleman's concern might be addressed in lines 219 through 22, where it says that gifts of a nominal value or donations of a nominal amount made on the occasions of retirement, death, etc., are permitted.
Okay. And last question, gentlemen. Hypothetical situation. And it's totally hypothetical because I don't have money like this in my account. But let's say I retire from office and I have $100,000 in my...
We're much too loud out there. Please keep it down. It's an important interrogation.
I have $100,000 in my campaign account. File my termination report. Create the Brian Clark PAC. Okay? Transfer the money to the Brian Clark PAC. Can I then pay myself $100,000 a year as executive director?
Gentlemen, you can transfer your monies to a PAC. You can create a new PAC. As far as paying yourself, I think there's some addressing of that language. If you're doing bona fide work and it's fair market value, that may be permissible. Again, it's a hypothetical. I can't answer every hypothetical, but in the prohibitions of the bill, it actually says, line 180, salary payments to a member of a candidate's family are okay as long as they're doing bona fide work, providing bona fide services. You can't set up a sham.
Right, gentlemen, I understand that, but it was my understanding from the gentleman's explanation is that once the funds are transferred to a PAC, then the laws that govern PACs will then govern how those funds will be distributed.
Well, again, gentlemen, I can't go too far down hypothetical roads.
Gentlemen, I'm in favor of your bill. It's some, what I believe, loopholes out there that I'm just... Well, hopefully in the future we can address it as a legislative body.
Again, this is not designed to be a comprehensive fix of every issue that's out there or every hypothetical. I don't know that we could even do that, but this is an important step forward to do some of the more obvious things that I think need to be done.
And gentlemen, last thing, again, something we can look at in the future. Occasionally, some of us are fortunate enough not to have opponents, general or primary. Was any thought given to relaxing the reporting for unopposed candidates to the very beginning and at the end, considering that if you give a $200 or more contribution, that the opposed candidate would have to report it anyway? So was any thought given to that?
Well, gentlemen, there are a couple minor provisions in this bill that do relax for unopposed candidates some of the reporting. For example, I can't point the gentleman to which line it is in the big part of the bill.
I think it's 513.
Well,
I was looking at that.
Let's see. But what I was going to say is you don't have to file 48-hour reports if you're unopposed, and you don't have to file the pre-election reports that are required for candidates in opposed races. But as far as the overall reporting of donations and expenditures, that's not relaxed.
I'd like for the gentleman to, in the future, take a look at that. Thank you, Mr. Speaker.
Thank you, gentlemen.
Gentleman from Lee, Mr. Holland, for a question.
Thank you, Mr. Chairman. Mr. Chairman, somewhere I was reading in the bill it speaks to $25 for poll workers. What is that about?
Gentlemen, I'm not sure. You're talking about the bigger part of the technical revisions?
It was underlined language, and I saw it on somebody else's desk. And of course, I'm computer illiterate, so I do not have a hard copy of the bill. But it speaks to being able to pay poll workers an additional $25.
Well, there is a provision, gentlemen, where counties can pay poll workers an additional stipend on top of what the statute says, and that may be that $25 language. The other thing is we passed a bill, it actually got approved by the governor, to allow municipalities to do the same thing, to equalize those payments that poll workers can get. I'm being told that line 2768, gentlemen, hold on.
Yeah, I think that's about right. Mm-hmm.
Oh, this relates to the training, I guess, and the certification that they have to go through, and the skills assessment that they have to do online and in person, and they get, I guess, a $25 stipend payable from the Mississippi Vote Fund.
And tell us the source of that fund. I'm not quite familiar with that fund.
Well, Gentlemen, the Election Support Fund was created when the legislature enacted the LLC annual filing requirement, and those monies went there and were to be dispersed by the Secretary of State periodically to counties. But the idea behind the provision that the gentleman's asking about is to have a certified poll worker in every polling place.
Mm-hmm. Okay. Does that constitute, in your opinion, or maybe I should ask the Speaker, is this still a majority vote because of that, or does that make it a 3/5 vote?
My understanding is still a majority vote, gentlemen. It's not a fee. It doesn't relate to revenue.
It's a donation.
Oh, no, it's not a donation, gentlemen. They have to go through certain things to be able to get that stipend, and this just sets up a payment that the county would make for the training through the Election Commission.
I recognize the gentleman from Jackson, Mr. Barton, for an introduction.
Thank you. Thank you, Mr. Speaker. Would everyone please help me welcome our George County Sheriff, Keith Havard, and the Warden of the Regional Jail, Bobby Fairley.
Gentleman ranking Mr. Baker for a question.
Thank you, gentlemen. I'm just now going through this bill. I hadn't had a chance to look at it beforehand. I do recall a meeting where we were talking about some initial drafts, and we were assured that the general prohibitions would be included, but the specific permissive things would not be included, the laundry list of those things, and of course that's been included. I do recall a meeting where we had discussed generally some concepts about this bill that weren't going to be included in the bill, and they appear to be included. Do I misremember the meeting that we were in that we talked about this, gentlemen?
No, gentlemen. Actually, the House position was not to include that laundry list of permitted items. The Senate insisted that we put those in. Okay. Well, I don't recall a call back where we had another discussion about that, but let's go on just a minute and talk about some of these things. Line 271 of your bill that you talked about, that we heard about, I have some concerns about, and I'm going to pull these apart and see if I can't get to it. But if we start at line 271, it says that candidate for public office who willfully violates shall be guilty of a misdemeanor and punished by a fine of $1,000, and, let's go on, a state assessment equal to the amount of the misappropriated campaign contributions. Is that right? That's right.
Now, when I read the word misappropriated, that's not willful. That's criminal, isn't it, gentlemen? That's a criminal word, isn't it?
Well, I think that's where this provision would fall under the law, gentlemen, is part of the election crimes, the general prohibitions on election crimes activities. Okay, and it goes on to say that the state assessment shall be deposited into the PERS system. But, gentlemen, line 277, no fine or assessment imposed under this section shall be paid by a third party. Right? That's what it says, yes, gentlemen.
So, gentlemen, let's talk about that a minute. You're telling me that if I get popped for an improper filing, that not anybody in the world, not my mama, not my sister, not my Auntie May, who feels like she wants to help me out, like everybody else who might get charged with a crime and have to pay a fine in this world and may have to call one of their family members to scrape it together so they can get out of trouble, you're telling me that not one other person in the world can help me pay this?
Well, first point, gentlemen, is that I don't think this applies to filings. I think this applies to misuse of campaign funds. I think there's a difference there. And again, the word willfully was put in there deliberately to make sure that there was an intent to basically take campaign funds and misuse them.
Yeah, but how did you become, how did the conferees become holier than thou and suddenly deign upon everybody in here that if you're done wrong and if you're found guilty, you're in it on your own and nobody can help you get out of that hole? Not anybody.
Well, gentlemen, I certainly don't think I'm holier than anybody in the room. I just think that campaign finance reform is important. The language that you're referring to, I think the intent of that is to not pay it out of your campaign funds and to not have lobbyists and others pay it as well.
Well, I appreciate what you think the intent is, but since we don't have any legislative history here, the intent is whatever a court says it is, reading the clear words on the sheet of paper. Now, gentlemen, you will agree with me, will you not, that if you read that sentence, there ain't no ambiguity there. can't be paid by any third party. That's everybody else, every entity, anybody else that's unaffiliated with me in my life cannot help me pay this. That's what you're saying.
I agree the language says what it says.
Gentlemen, let's go to line 2. I'm looking at, and again, I'm pulling this together, but I'm looking at the provisions of the law that talk about the filing of lines 412. And I think that this was intended to address neophyte political committees that may get involved on a particular issue, may become concerned and decide that they need to organize to engage on a particular issue. But it appears to me that what you're saying is if a political committee forms and they do not within 48 hours file a report, now not 49 hours or 50 hours, if they don't do it within 48 hours and file a report of filing and qualifying and this when they receive funds, what we find in this is not only are they subject to the assessments and the costs, but they're also subject to, if I can read it right on lines 436, they're also subject to a $5,000 fine per violation. So if they got 2 checks for $201 and they were on the 49th hour, they're potentially exposed to $10,000 in fines. Is that right, gentlemen?
Well, gentlemen, my understanding is this language was in the bill that we voted for in the House and passed out. In other words, the intent of this is to curb these late filing PACs that funnel a lot of money through right before the election. Under the current time frame, they don't have to file their statement of organization or any information about themselves until after the elections. So the reason that 48-hour period is put in there is actually to require these PACs to organize in such a way that voters will know who's sending out anonymous mailers or who's sending out these things before the election actually occurs.
Well, that just sounds to me like people with thin skin get mad because people get mad at them. What I'm asking you, gentlemen, is do you agree or do you disagree that if that organization doesn't file the report documenting a $201 contribution, that each of those contributions can be considered a violation, and each violation carries a $5,000 fine in addition to the other assessments, potentially?
It does say $5,000 per violation.
So what we're essentially trying to do is bankrupt the opposition if they come after us, and maybe they're a little disorganized, maybe they don't get all their paperwork together, but what we're trying to do is just bankrupt them into submission so they can't come after us individually. Is that what we're trying to do, gentlemen?
Not at all, gentlemen. I think what we're trying to do is clean up our election process so shadow money comes out into the open before the voters make a decision.
Well, gentlemen, you would agree with me that not everybody that forms a political action committee on the fly trying to get involved in an issue is going to get all their paperwork lined up. But instead of taking a fly swatter even and trying to address this issue, instead of trying to find some way to encourage these groups to come together and to come into compliance, what we're trying to do is actually just beat them into the ground, into the mud, so to speak, so they won't ever come back and mess with us. Now, gentlemen, in our country, would you submit that the free speech and the ability to engage in the political process is what we want? We don't want to try to get people out of the process.
Absolutely.
And can't we take a little chink in the armor, and can't we take a few slings and arrows when groups are trying to get engaged in the process as opposed to slam the door and shut the door and keep them out of the process?
Well, again, gentlemen, the language that we're discussing allows the Secretary of State, doesn't require them to impose the penalty. It provides for due process. It provides for administrative hearings and all those kind of things that are set out in law. And again, the intent of this is certainly not to penalize new PACs from forming or anything like that. It is to keep shadow money out from manipulating the system close to an election so that once the election's over, they finally have to file something after the fact.
Gentlemen, I will ask you a few more questions now. It's my experience that sometimes in political process, like in municipal elections, county elections, and stuff like that, let's just be candid. All those reports don't all get filed exactly right. If you're running for alderman in Tumsuba, so to speak, you might not get it quite right. Would you agree with that?
I would. Yes, I would.
Okay. But when I go back and I look at this bill, and I look at the provisions, it's particularly with regard to lines 513 through 517, we say, oh, by the way, this bill is going to apply to everybody in every type of somebody who runs for office, regardless of your abilities, your knowledge, your understanding of the law. And what we're going to say is we're going to put the hammer on you too. Now, gentlemen, what concessions does this bill provide, if any, because I hadn't found them, for the concept that somebody new to the process may not get it right? It looks like we can two-foot them too, so basically all I need to do is just be trolling for people that are running against me and just make sure they don't do that, and then all I can do is just run to the Secretary of State's office and have them in court from then to the time of the election, and I don't have to worry about a thing, do I? Because I know the rules. I've read the bill.
Well, gentlemen, the line that you cited me to, 513 through 517, actually doesn't change current law, I don't think, in terms of reporting requirements. It actually relaxes the law that is applicable to unopposed candidates. That's the gentleman from Holmes had asked me about pre-election reports and the other things that are filed right before an election. Those are relaxed, but otherwise those reporting requirements currently exist.
Well, except for the fact that all of the requirements that you're placing on us are also going to apply to them, gentlemen. What I'm asking you is I've read this bill, and I appreciate what you're trying to do. Unfortunately, I didn't read it till today. I guess it got filed late. But I had an understanding about what it was going to say and what it was going to do. Okay? Separate and apart from that, I look at this in a situation. I want to ask you about this because I want, there's all the time litigation and fights about campaigns and stuff after the fact. But gentlemen, isn't it a fact that what we're essentially creating is a means whereby incumbents who know the rules can basically money whip their opponents and get them under complaints and constant scrutiny by the Secretary of State, the Attorney General, and whoever, to the point that they can't run for office, but rather have to defend themselves from running for office. You don't agree with that, do you, gentlemen?
I don't, gentlemen.
You don't agree that what we're essentially going to create is a class society with regard to elected officials where those that know the rules can beat down those that don't know the rules, to the point that nobody's going to want to run for office that's not run for office before, gentlemen?
I don't agree with it, gentlemen, and I would say what this bill does is actually apply rules to the people in office who know the rules best and are manipulating those rules to benefit from campaign funds that they shouldn't be benefiting from.
Gentleman from Madison, Mr. Blackman, for a question.
Thank you, Mr. Speaker. Gentleman Yale.
Yes, sir.
Gentlemen, I want you to consider the 122 members of the House of Representatives being a gnat. And I want you to consider this bill to be a hammer. And I want you to explain to me how this hammer comes down on these gnats. Let's start with Section 7. I believe Section 7 is the provision which the administrative part of this bill kicks in if there's a violation or a presumed violation. And can you explain to me what happens starting with the Secretary of State's office and thereafter when there is a complaint or a suspicion that there has been a violation of the Act?
Gentlemen, again, as I understand it, we've debated this bill fully when we passed it out of the House. I don't think this language changed at all in the conference report, and most of this appears to be current law. I mean, it's 25.
Jim, this is what I'm getting at. We passed also in this House early voting, and I know we got various bills have now come to play into this bill, into this conference report. There are ideas and sections taken from various things that we've done before that are in this bill. This conference committee report. So what I know is the early voting was not in there, so there was some compromises made. You just told me that this was in an original bill that came out of this House, and usually in the conference you try to trade off certain things. So we traded off the 14 early days of voting. We left this part in whatever bill it originated in. But I'm asking you, since it's in the conference report, can you explain to the membership what they're about to vote on that's in Section 7?
Well, gentlemen, I will say this. We did not negotiate or discuss the great bulk of this bill. In other words, early voting wasn't on the table. Online voting registration, those were separate bills that once they jettisoned from here and we passed them, they went over to the Senate. This bill, the great bulk of it, is exactly as we passed. The things that I've been talking about as far as campaign finance reform, those are added at the beginning of the bill in sections 1 through 6, I think it is. And the rest of this bill we've already approved. Now, in Section 7, gentlemen, I'm trying to remember what the changes are to this statute because it was already there. I mean, in other words, it sets forth filing of the reports, the timeline for filing them, the current law as it exists. And I think what the bill does is simply update those provisions to reflect practice and reflect changes in technology.
Mr. Speaker, I can't hear, and I'm a few feet away from the chairman there.
The gentleman indicates you cannot hear. Please hold the noise down.
He's not.
Gentlemen, the Section 7, the section that's involved there, the only changes are cleanup language.
Well, no, I think it goes a little further. It provides for an administrative process whereby the Secretary of State can investigate any alleged campaign finance abuse, can assess a fine or waive the fine if he so chooses. And you're entitled to a hearing, I believe, under that section if you want a hearing. And if the hearing is convened, then I believe you have a hearing committee comprised of some members of some courts, some chancellors, some circuit court judges, maybe say it's formal. There's a right of subpoena there and a right of to have a hearing and a ruling within a certain amount of time. And if you're displeased with that ruling, you can appeal it to a judge here in Hinds County, Mississippi. Is that all in that section?
Well, gentlemen, I guess I'm a little confused in following the gentleman's question because this is, as I understand it, is current law, but it is also unchanged from the bill that we passed out of the House.
Gentlemen, everything I just told you is underlined as being new to this bill.
In Section 7?
Yes.
Of the bill?
Yeah, I'm looking at it here.
Starting at line 640?
It doesn't show lines on our computer. I'm looking at the conference report. It says conference report. Am I reading it right?
Gentlemen, we may be ships passing, but in my Section 7, there's very little change in its cleanup language, and again, we didn't address that.
What I just stated, you're saying that's current law?
In Section 7, yes. Except for the cleanup language that was part of the bill that we passed.
Here you go. Well, they may have taken it out. Is it not the conference report that's on the computer is not the one that we have before us?
No, it should be.
It's not? It doesn't show lines on the computer.
Gentlemen, I'm looking at
I'm going back to it now.
Section 7 starts at line 640.
Well, gentlemen, tell me this while we're looking. What is the appellate procedure, the administrative procedure for contesting a fine by the
Gentlemen, are you referring to an election contest?
No. I'm referring to in the event that there's a finding that you have violated the campaign finance provision of the bill.
Well, if you fail to file a disclosure form or if you file it late, the Secretary of State's office can impose a fine for failure to file, and I think that's what Section 7 is addressing. You can submit an appeal, and just in practical terms, if you submit your reasons for why you failed to file or failed to file on time, the Secretary of State's office can weigh that, and they'll decide whether to waive the fine or reduce it or otherwise. It's fairly informal process, but I think that's what Section 7 is after. That's not changing the current law.
Can the Secretary of State now waive that fine?
Yes.
And if you choose to contest that finding by the Secretary of State, what happens next?
I think, gentlemen, it follows the normal administrative course. I'm sure that you have an appeal to the head of the agency, which is the Secretary, and if you are aggrieved by his decision, you could go to court.